Lasting powers of attorney are legal documents whereby you appoint people you trust implicitly to make decisions on your behalf if, in the future, you lack the requisite mental capacity to make such decisions for yourself. Lasting powers of attorney do exactly what they say. They last despite the onset of mental incapacity. There are two types of lasting power of attorney. One deals with property and financial affairs, and the other for health and welfare matters. Lasting powers of attorney must be registered before the attorneys can act. However, under a property and financial affairs lasting power of attorney, your attorneys can act immediately even if you do not lack mental capacity. You may be physically frail or too ill to deal with your own finances, in which case your attorneys can step in and act and help you immediately. Of course, they are always acting on your instructions. Under a health and welfare lasting power of attorney, your attorneys can only act if you lack the requisite mental capacity to make decisions for yourself. Because, of course, whilst you retain mental capacity, you decide where you live, how you dress, who you see, and whether or not you're going to give or refuse consent to medical treatment. Your attorneys under a health and welfare lasting power of attorney can also be given the authority to give or refuse consent to life-sustaining treatment on your behalf. They can say whether or not you should be resuscitated or given medical treatment to keep you alive. They are very, very powerful documents, and therefore you need to be very careful who you choose as your attorneys. You should treat lasting powers of attorney as though they are insurance policy. Put them in place. Hope to goodness they are never used. But if the time comes when they are needed, then you will be certain that you have appointed people you trust implicitly to make those decisions for you.